Jurors, hearken your verdict as the court records that you upon your oath say the defendant on 001 is not guilty, on 002 is guilty of operating in the influence of liquor, and 003 not guilty. Thank you.
All right, jurors, everybody please be seated. Jurors, we thank you for your service. We're going to send you back. Your service is complete. I'd like to come back and talk to you for a little bit afterwards. So thank you very much.
And thanks for joining us. I'm Gene Valicenti. We're doing a special edition of 10 News Conference. You know, we've done about more than 40 debriefs every day of the Cameron Reed retrial. So we thought we'd assemble our panel of legal experts that have been joining us at NBC 10's Katie Benoit, who did the heavy lifting on the reporting in the courthouse. Good morning to all of you. And I'll introduce you in alphabetical order. Katie Benoit. Austin Dana is with us, attorney. Attorney Morgietta DeRizier and attorney Peter Ellikin. They all practice in Massachusetts. Thanks for all your help during the trial, and thanks for getting together for this special edition of 10 News Conference. All right, we know the verdict is in. We know that she was cleared of the most serious charges. She was found guilty of really what is a footnote charge in the scheme of things. Operating under the influence is wrong. We understand that. It's not a good thing, but in the total scheme of things, it's really a footnote charge. Now, show of hands, panel. Who is surprised by the verdict? Show of hands. I take that as a unanimous. No one is surprised. Did anybody think it could go the other way? Show of hands. No. I thought
there was a small chance there could be a deadlock. I never ever thought you would get 12 people to find her guilty, though.
All right. So this verdict makes sense to you, Peter Ellikin?
Yes, it does. It was just way too much reasonable doubt. I mean, we start from the beginning. There was never an eyewitness, never a video. And so during this trial, every time there was an expert for one side, the other side effectively cross-examined and knocked holes in some of the experts a bit. And they had an answer for everything. And I think the jury at the end, it just wasn't proven beyond a reasonable doubt. There was, even if you were confused and said, gee, this person said this, the other person said the exact opposite, I don't know who to believe. Well, that's reasonable doubt. It's that old expression, tie goes to the runner. And it's not as if as we all know, it's not as if the defense had to prove her innocence beyond a reasonable doubt. It was that the prosecution, it was on them, the burden. They had to prove she was guilty beyond a reasonable doubt. And that's such a high standard. And it just didn't seem like it was ever, they ever really nailed it. They didn't have a smoking gun. They didn't have proof positive.
All right. So the assembled panel, no one here is surprised. All right. Morgietta, let me go to you. Strongest point that you think the defense made. And then, Austin, I'm going to ask you strongest point that the prosecutors made. Morgietta, you go first. Strongest point.
So I can't say there was one particular strong point because they made a lot of really strong points. And I think it really just boiled down to the cross-examination of the prosecution's expert. They did a fantastic job about making sure that whatever the prosecution put forward, they were able to capture that reasonable doubt. Again, the jury is only being presented with what's directly in front of them. We had the luxury of Googling and being on Twitter and having all these outside forces, but they only had directly what was right in front of them. I mean, the prosecution's strongest point clearly is the video clips that they put throughout the trial, right? And what do you do about your client who has all these interviews and, testifies outside of court? You do the best that you can, but I would say that was the prosecution's strongest point.
Austin, you weigh in now. Strongest point on the defense's side and strongest point on the state side.
Yeah, I think the defense did an excellent job bringing in their own experts to rebut the prosecution's experts. And their experts seemed much more qualified. Their scientific tests that they were doing were much more elaborate. Alan Jackson referred to the prosecution's scientific tests as kindergarten projects, putting paint on your arm and seeing if it bumps the SUV on the taillight, if you hold it out in a certain way. So I think the defense had great experts to rebut the prosecution. The thing that the prosecution had going for them, I'd agree that those video clips were pretty damaging and great for the prosecution. They also had the cell phone data and the black box data from the SUV showing that it backed up at 24 miles an hour right around the time that Mr. O'Keefe's cell phone stops moving around and starts getting cold. I think that was the strongest thing that they had going for them.
Katie, you were up there almost every day of the trial. You covered most of it. You did the heavy lifting. Was there a sense of surprise, or no? Anybody who was up there every day watching this, the crowd outside, they pretty much felt it was going to go this way.
I think that it wasn't a surprise, the verdict, when it came back, because of those jury questions. They kind of offered some insight as to what they were thinking. So I think when they were focusing in on that OUI charge, it wasn't a surprise that they came back on just guilty on that. But I do think, there was weeks worth of evidence, and there were 12 people that were deliberating. So I kind of thought maybe possibly there could be another mistrial, or there might be a charge they might not be able to agree on, just because there was so much evidence, and getting 12 people to agree on everything, it's pretty difficult. So I was a little bit surprised that they were able to reach a unanimous decision, actually. So
yeah, Peter Ellikin, you remind us, not guilty just means that the evidence isn't there to convict you. It doesn't really mean in the vernacular or outside the courtroom that we've proven that you didn't do it. It means not guilty. Just that's a fine point.
That is correct. There's nobody. They didn't at the end declare her innocent. They just said not guilty, which is often too bad, because very often somebody will be found not guilty at a trial, and a lot of people say, "Well, it was a technicality, or they just didn't have enough evidence," and you don't get to clear your name. But again, they just didn't. They just didn't do it.
It's the way our system works. Austin, was there anything that surprised you at all while you watched this trial? I know we're all in agreement that all three legal analysts said that she's not going to take the stand. You're all in agreement on that. Did anything pop out or strike you as odd? Wow, I didn't expect that.
I mean, there are a lot of twists and turns throughout the trial, and it was a long one with a lot of surprises. I think one thing that stuck out to me was Miss Devers' testimony. When she got up on the stand, I think that was a turning point in this case. She was very combative with Alan Jackson, holding back, not directly answering questions, but eventually had to spill it that she had told the FBI investigators one thing, and now she's claiming that was a false memory after she met with the Boston police commissioner. I think that was a surprising bit of testimony and was really a turning point in the trial.
And for those of you, those of our viewers who haven't been following this as closely as we have, Devers is whom? And make that clear.
She was one of the police officers on the Canton police force at the time.
Right.
She was called in to sit at the dispatch desk while other police officers went to the scene. She had made a statement to the FBI that while she was at that dispatch desk, she saw some witnesses in the Sally Port around Miss Reed's vehicle, and then she later recanted that statement.
Okay, and she is now a Boston police officer, I believe. Isn't that correct? She's moved.
Correct.
She's moved on. All right. Let's give a good recap of what we believe to be the facts in the case. I'll begin with you, Morgietta. Karen Reed's story never changed. I was out drinking. I was drinking a lot, and we drove over to the after party, and the lights were dark. And I said to John, "Get out and see if the party's still on." And I saw him get out and go in the car and go in the door, and he closed the door, and that's the last I saw of him until I came back hours later and found the body on the lawn. And in between, she said, I got angry and I left on my own. Is that our understanding? That never changed, Morgietta?
Yeah, that never changed. And I think it was very clear, even when she was doing the interviews with some of the other stations and things of that nature, that never changed. She was very open and honest that they were all drinking that night, including her. And I think that it goes to the testament to, what we're looking at as far as reasonable doubt and her innocence. She said, I think I hit him. Did I? I'm not sure. Right. Yeah. And she said in one of her video clips, the first thing I did was I called David Yannetti and talked through it. Right. So she has maintained her story throughout this entire trial.
Right. And Peter Ellikin, the state's prosecution, that basically never changed. She was an angry person. They'd been out drinking and she took advantage of an opportunity. She backed her car into him deliberately to if not kill him, to injure him. Is that our understanding on the other side?
That is true. And again, there were no, as we say, smoking gun or no proof positive to nail somebody.
Right,
You know, every
yeah.
so often a video will come up or something. It wasn't here. So the DA just kind of tried to use building blocks and tried to put together a story that apparently she was drinking. We heard they had this couple who had some spats in the past. She was acting irrational. She was and that business about she was saying, could I have hit him? She was distraught. Right. And then they kind of tried to piece together some of the forensics. And I don't know that they did such a great job. It was really like kind of a head scratching thing where you say, okay, she hit him and he flew through the air at least 10 feet. And yet there's not a mark on the body, and only his arm has some abrasions on it, but there's no broken bone, not even a bruise on the arm. And the story, I don't know that they never really put the story together, but for one, it looked like they were, as we say, putting building blocks together. You don't need, videos or proof positive all the time. There are a lot of cases that have been proven.
Peter froze up there for just a second. That's a good cue. Peter, just stand by. We got you back. Folks, you stay with us. We're going to take our first break, but we'll be back to separate fact from fiction. A lot of stuff that you read on the internet and on social media that may turn out not to have been true. And plus, we'll talk about what's going forward with a civil suit that's coming up. This is 10 News Conference. Stay with us.
I just want to say two things. Number one is I could not be standing here without these amazing supporters who have supported me and my team financially and, more importantly, emotionally for almost 4 years. And the second thing I want to say is no one has fought harder for justice for John O'Keefe than I have and my team. Thank you.
You want to tell us how you're feeling?
Happy. I'm happy. Thank you.
What is that weight like off your shoulders?
Any words for the O'Keefe family?
I fought for John O'Keefe harder than anyone.
All right. That was Karen Reed outside court right after the verdict. And then reporters caught up with her later that night celebrating in Boston. And she said that twice. Nobody fought harder for John O'Keefe than I did. Latest interview she did just a couple of days ago, she said, we all know who the real killer is. And then the reporter pressed her, and she said, I'm not going to say I'm concerned about libel. We'll be discussing that with our panel that's rejoining us, Morgietta DeRizio, Austin Dana, and Peter Ellikin, and NBC 10's Katie Benoit. Before we get to the libel issue and whether or not there is a libel issue or a slander issue and the civil suit to come, let's kind of separate fact from fiction, because this thing played out on the internet and on social media and Twitter and everywhere else. And you know what happens on platforms. Some of it's true, some of it's not. So let's begin. Morgietta, the basement floor was almost, I want to repaved, or the concrete was relaid, and the house was sold, and that's suspicious. True or false?
I'm sorry. It's very suspicious. Not only that, the dog was rehomed. There were so many things that you could point at, and I don't think any one of them in particular would be very, unorthodox, but I think the combination of all of these things happening in the middle of a murder investigation where you have, federal court orders and you have orders, people disposing their cell phone. It's the accumulation of all of these things that are happening that makes it seem very, very strange that you would do that. Because in a lot of trials, you try to preserve the evidence as much as you possibly can, because you don't know what's going to come up. I mean, even in this trial, I think halfway through, there were still new reports coming out. So it is unorthodox, and it is a little strange that the driveway is being repaved, the dog is being rehomed, and things like that. It was a little weird.
Katie, the dog was rehomed. That's the term they're using. And the police actually tracked down the dog. They found the dog. Anything to add there? This is Chloe, the dog.
Yes. So Chloe, I guess, did have a history of being a little not getting along with other dogs. There was a couple instances, I think, that were talked about in the first trial of her maybe getting into attacking another dog. So there was a history with Chloe there, and that's why she was eventually rehomed.
It was a speculation that Chloe provided the wounds that were on the arm, or I believe in court, the medical examiner said it was consistent with an an animal. All right, let's go to Austin Dana. Cell phones were destroyed. Cell phones were driven to the Cape and destroyed, and people inside the house did that. Your take on that? True, false? And what do you make of it?
Yeah, I don't think there's any debate that that's true. I think it's clear that before an order came down ordering Mr. Higgins to preserve his cell phone, he destroyed it, drove it to a naval base, and threw it in a dumpster. That's suspicious behavior. Yeah. Certainly suspicious, and I think it happened. Now, what his motivation for doing that was, I don't think we'll ever know. Was there something on there not related to the trial that he just didn't want coming out? He didn't want people discovering? Yeah. Or was there actual evidence on that phone that would have linked him to Mr. O'Keefe's death? We don't know because he destroyed the phone. And again, that's extremely suspicious.
Peter Ellikin, across the street, there was a Ring doorbell cam that would have had a clear shot of what transpired, but the video wasn't available, and the homeowner is a cop himself, and this plays into the cops watch out for each other. Is that your understanding of that angle?
Yes, it is. And I'm going to kind of take off on what Margietta and Austin were just saying, that all this leads to the idea that when people now ask, okay, she didn't do it, who did? Yeah. I don't know that we'll ever find out because of all the things you just pointed out here, that they didn't. Perhaps if they had looked to see if there was a Ring camera, perhaps if they had interviewed the people who were in the house, perhaps when, the chief investigator there, Proctor, hears about a body in front of a house that was supposed to go to a party and doesn't even look inside the house to do any investigation. And then, of course, they rehome their dog. And all of us who have dogs, who would rehome their dog after 7 years together? Seems like an impossibility, and redo the basement. And obviously the cell phones were wiped clean. So then you turn around and say, hey, you can't point to anybody else, right? And yeah, what's your first clue? And that's why they did such an incredible job of either bungling the investigation or wiping out the evidence, that now at this point, 3.5 years later, I'm not so sure they're ever going to have any evidence against anybody else. That's wiped clean.
Katie, all kinds of talk that they all knew each other. The cops knew Judge Cannoni. They called her Auntie Bev. Relatives of hers presided over earlier cases involving brothers and sisters. Just nutshell that for us. And then we're going to talk more about the lead investigator, who was the lead investigator, Proctor. Go ahead on Auntie Bev, Judge Cannoni.
So I think there was a lot of talk on social media, people saying things. Obviously, the county, the Canton area, it's a tight town. A lot of people know each other. And that was kind of one of the things that came up in this case a lot. A Boston police officer owns the house. A Boston police officer is found dead on the lawn. There's other members of law enforcement inside the house that night. They all know each other. And there were so many connections in this case. I feel like I don't think it came up as much in the second trial as it did in the first trial, because a lot of the people who had these connections didn't testify this time around, like Brian Albert, Michael Proctor. But obviously, it's a very tight-knit town.
All right, time to take another quick break. Panel, before we come back for our final segment, I want you to think about social media's role in all of this, the bloggers, how much. This is 10 News Conference. We'll be right back. Welcome back to the special edition of 10 News Conference. We're recapping the action in the Karen Reed retrial. We've done about 40 debriefs, so we've assembled our panel of legal analysts and reporters who've been helping us through this. I suppose you could call it an ordeal. It was a heavy lift, and whether justice was served, I guess that depends on what side you're on. Before we left, we were talking about the lead investigator, Proctor. How much do you think the jury knew about him? His name came up in court, but he wasn't called because he's damaged goods. He was fired and disgraced. How much do you think the jury knew about him, and how much do you think they knew about witnesses that were called the first time around, weren't called the second time around? Margietta, start with you.
So I think during the jury deliberation, that was one of the main questions that I recall the lawyers specifically asking the jurors, is whether or not they heard about this case. And I want to say it was either 80 or 90% of them had already heard about this case, but it didn't affect their ability to sit on the second trial to be unbiased jurors. So I don't think it was a mystery that they knew who Trooper Proctor was, but it clearly didn't matter to them because they didn't need his testimony. We got the text messages in, the damaging text messages in. Right. They got the issues with some of the evidence being signed or not signed. So a lot of information came in without him actually sitting on the stand. And I don't think it made an overall difference whether or not they could find Karen Reed guilty or not.
All right, Katie, you did a good way of explaining that this defense was Police botched the investigation. Last offense was somebody else inside that house. A third-party culprit was responsible. Just quickly take 30 seconds on the difference.
So this time around, the defense went with a Bowden defense, basically saying the police didn't do their job properly. They didn't investigate anyone besides Karen Reed, that they probably should have gone inside the house. They collected evidence with red Solo cups. This was evidence that was all presented to the jury. And last time around, the defense was more focused on somebody else did it. Somebody else had the means and motives to kill John O'Keefe.
Austin, Dana, how much social media, how much media in general do you think this jury consumed? Because I don't believe that they never watched the newscast, never listened to a broadcast, and never saw it on Twitter or Instagram or Facebook. It's a hard sell. What do you think?
Yeah, they're instructed not to. They're instructed not to look at anything in the media related to the case. And every morning when they walk in, the judge asks them, did anybody look at anything? Is there anything that you need to tell me? And they all say no. But in reality, this case has been everywhere and it's been impossible to avoid. So I'm sure that somebody's seen something, although I'd like to think that if they saw something, they did their best to ignore it. I think the jurors, as a general proposition, take their job very seriously and try to follow the court's orders. So maybe they saw something here or there, but I don't think anybody was walking into that courtroom and lying to the judge and going home and getting on Twitter and looking at blogs and stuff related to the case. I'd hope not.
Peter, can laymen and reporters make too much of this? Well, what if they did see a newscast? What if this or what if that? It's the world. Are we making too much of it?
Well, actually, I mean, you really are supposed to just be focused on the evidence you hear in the court. And that's why, as I understand it, a lot of these, one of the jurors has already been interviewed, and he said that it was kind of divided. Either members of the jury thought she was not guilty, or a few weren't that convinced, but they also said it wasn't proven beyond a reasonable doubt. So it is good to be focused on just what is the evidence and not consider anything else. But gee, in this day and age, I don't know how you're bombarded in every direction. Maybe in the 1950s, it was you turn off the TV and that was about it. And you weren't going to get bombarded. But now with every direction, with text and friends emailing and, on social media, and everybody's on the honor system. And I agree with Austin. I think juries do surprisingly take their job very seriously, and they usually do the right thing. Not every time, but almost every time. And they probably were I would guess that they were probably very, very conscientious here.
All right, let's begin the way we started. Show of hands. Have any of you ever seen another case like this? With the exception of OJ, crowds outside, supporters, shirts, signs. Anybody, show of hands, ever seen anything like this? No, and you'll include me in that, and I've covered a lot of trials. Do we all agree that a lot of this fan base, it was driven by social media? Is that how it's explained? We're all in agreement on that. All right. Let's go to what's coming up, and that's going to be a civil trial. Katie Benoit, we just got 1 minute. We'll have to make the answers tight. Katie, the paperwork's been filed?
Yes, it was filed after last year's mistrial. So,
Austin, the threshold for guilt is a lot lower on a civil side?
Yeah, on the civil case, we're looking at a preponderance of the evidence. Is it more likely than not, rather than proof beyond a reasonable doubt? Much lower burden of proof on the civil case.
Peter, she could be deposed, and that's a different ballgame. Just shortly, quickly.
Yeah, that is true. So she will probably at some point really have to be interviewed and talked and talk at great depth by the prosecutors. I mean, not by the other attorneys on the other side. And she didn't have to do that during this criminal trial.
And Morgietta, I'll give you the last word of about 10 seconds. It's not over, right?
It is not over. Not over yet.
But it's over for us. Thanks to all of you for your work throughout all of this. I appreciate it. This is 10 News Conference, your longest running political show. We'll be back next week. Have a great rest of your week.